All rise. The Court of Appeal in the Fourth District of the State of Florida is now in session. The Honorable Carrie I. Evander, Chief Judge, presiding. All persons having business before the court draw near, give attention, and you will be heard. May God save the United States of America, the state of Florida, and this honorable court. Please be seated.
Okay, good morning and welcome to a session of oral arguments of the Fifth District Court of Appeal. I've already been introduced, but let me go ahead and introduce the other panel members. Sitting to my right and your left is Judge Jay Cohen, and then to my left and your right, Judge Rand Wallace. We have two cases scheduled for oral argument. Both sides will have 20 minutes aside. If you want help as far as the appellant keeping track of their time, just tell me how much time you wish to reserve for rebuttal, and I'll help you out in that regard. After the first case, we'll have a panel change. Judge Eisnagel will be replacing me. We don't plan on recess, and I'll just step out, and he'll step in, and that'll be the panel for the second case. If you have a cell phone or any electronic devices, make sure they're turned in silent mode so that the attorneys are not interrupted in their oral argument. All right, first case will be Dunn versus Dunn.
Thank you, Your Honor. May it please the Court, I'm Michael Korn of Korn & Ziemer of Jacksonville. We represent the appellant, Patricia Dunn. I would respectfully request 5 minutes for rebuttal, please, Your Honor.
Okay, you may proceed.
Thank you, Your Honor. As the Court's aware, we've raised several issues stemming from this judgment of a post-judgment modification case. We may not get to all of the issues, so before we get started, I do want to just stand on my briefs as to any issues we don't get a chance to argue explicitly.
So let me ask you this. Do you believe that the court's consideration of decreased needs is adequate grounds for modification?
It might be adequate grounds for some modification, Your Honor. I would respectfully submit that, assuming that it was an appropriate consideration of decreased need, it doesn't yet reach the affirmance that the appellee would require in this case.
Well, I just want to make sure then we're on the same page with that. There's a case, you've got the Wolf case out of the second, you've got, no, I'm sorry, the Wolf was actually out of the fourth, then you've got another case out of the second, and those cases stand for the proposition that modification based upon decreased needs in and of itself is sufficient ground. Are those cases correctly decided?
We certainly didn't object to to the holdings in those cases. Those were all in the briefs.
Well, then you accept them. If you don't object to the holdings, then you accept them as correctly decided. So that being the case, you've got findings from the trial court that the former wife's needs decreased, that all of her expenses went through the investment account and they were ascertainable, and they had decreased from $17,000 at the time of the final judgment to $8,000 or so at the time of the modification. Why then isn't that within the trial judge's discretion?
While it might be within the court's discretion to make some modification, Your Honor, the approximately 85% reduction that was occasioned in this case resulted not just from a finding of supposed decreased need, but also upon the court's, we believe, erroneous determination that an unanticipated change of events had occurred, that being the growth in the investment accounts.
I didn't read the final judgment that way. I read the final judgment that there were alternative grounds for the granting of modification. One was the substantial growth in the portfolio, and I do have some questions about that. But I think that alternatively, is the way that I looked at it, alternatively, the wife's decreased needs were the second basis for granting modification.
Your Honor, I understand the court's question, and I appreciate its premise. The point I'm trying to get to the court is this. Here, while there might have been some change from the $12,000 monthly alimony amount, even if you accepted all of that, without considering the drawdown of the assets from the Merrill Lynch account, you don't get to the 85%. So in other words, you can't just take one factor. There are two factors really dealing with the decrease. One was the wife's need decreased. I would submit, though, while the numbers did show a decrease, even by her own financial affidavits, of course, it, to some extent, goes against the concept of the wife being able to maintain the marital standard of living. I would suggest that didn't occur.
Well, that's I think the question we're trying to get an answer to. Let's assume that the marital standard of living was set at $17,000. Okay. Now, there can be needs that you no longer have. For instance, maybe there's a medical problem that was causing you $1,000 a month need, and then it's gone. Or maybe you have, some other need that is no longer existent. That's one type of need, but how about the person who just spends less money? Decides they're going to go out to eat less, they're going to travel less, they're going to buy clothes that cost a little less money. Is that, something that can be a basis for modification as far as determining need, or do you still go to the need for the marital standard of living, assuming that the payor has the ability to pay?
And that assumption, first, to the last part of your question first, Dr. Dunn's ability to pay was never challenged. He said as such, and in fact, the court even told.
No, we're aware of that.
Okay, thank you. So the issue here is, for instance, can needs change during a period of time from the 2000 amended final judgment through the October 17 trial? Sure, they can. In this case, Your Honor used an example of medical expenses. This is precisely one of the things that the analyst that the husband hired to do this needs analysis was ignoring, considering them to be either one-offs or not recurrent.
That report did come in without objection.
It came in without objection. There was some question as to the weight that it should be given. There was, and Your Honor, you could say that should it have been objected to, it was not disclosed until a week before the trial. McGill was never deposed. But Your Honor is correct. There was not a specific objection interposed to the report. But to that extent, the methodology that the analyst used by basically taking a stale period of time, almost 2 years prior to trial, and then just explicitly saying, I'm ignoring insurance that she might have, I'm ignoring hazard expenses to the home.
Going back to Judge Evander's question,
yes, sir.
I think that his question goes more towards the nature of the decrease in expenses.
Now, the bigger question, do you determine need based on the marital standard of living, and is it a basis to reduce if the recipient of the alimony is simply being more conservative in his or her spending?
Well, Your Honor has raised a policy question that the cases talk about, and frankly, I've seen cases going on either side of that analysis. There are cases that say if the spouse voluntarily decreases their standard of living, is it required that the numbers necessary to maintain the prior standard of living be maintained? Interestingly, in this case, at the time that Mrs. Dunn should have hopefully been at a more secure part in time of her life, as a result of this order, which not only substantially, and I mean 85% substantially reduced her alimony, but also required a approximately $400,000 retroactive repayment to Dr. Dunn, puts her not at a point of security, but a point of heightened insecurity. So to your question, Judge, about at what point in time on the continuum do we look to this? It's an ironic thing that if a spouse tries to be responsible, if a spouse doesn't overspend, a spouse tries to live within her means, it can be used against her. If the spouse had been profligate, if the spouse had gambled the money away or gone to spend it.
But that's why I started by asking you whether Wolf and the cases out of the second were correctly decided, because that is what they say, is that simply the decrease in spending alone is an adequate basis, and there is that policy, which is that you reward folks, or you're going to punish someone for being conservative in their spending, and the alternative is spend everything. That's the other message that gets sent. That way you're not punished.
And that raises a policy question, I think, for this court to consider in the context of this case. Because I'll come back to the question, Judge Cohen, that you started with, which is, would there be some amount off of, say, the 12 per month that could be appropriate? And I would say yes.
And is that the relief that you seek? So are you effectively asking this court to order a new trial?
I think it needs to be reconsidered for a variety of reasons, because the trial court...
I'm asking, the question was, what relief are you seeking?
The relief would be to remand this case to reconsider an amount of alimony that is commensurate with the wife's true needs, not the needs as found by the made-as-instructed report, and an amount that takes into account income.
Well, but those needs were based upon the amount spent, which the wife acknowledged were accurate. You know, there was an investment account, and everything ran through the investment account. And the wife testified that, yes, all of my expenses, or almost all of my expenses, run through that account. And so if that's where he pulled those numbers from, those are accurate.
Your Honor, that's true, but as I said, it is stale, A, because it is almost 2 years in the past. Secondly, it was subjective because the analyst used his own determination as to what he considered to be one-offs or not appropriately considered in the wife's need. And you know, you can go through the report. It's at page 3291 of the record, and you go through the deductions. For instance, and it may be a small matter, he deducted a substantial amount for food because at a point in time her elderly father was residing in the home.
Mr. Carter, we're trying to look at a bigger picture here. I'd suggest there was disputed evidence on her actual needs, and the judge could find one more credible than the other. And I know one of your issues is that their expert was off, but let's assume that we find that the judge had competent evidence to determine that she was spending X amount of dollars per month as indicated by their expert. You know, to me, the bigger question is that a basis for modification, yes or no, going back to Judge Cohen's point about, you know, do we punish someone for being thriftier? Do we reward them for not? So that's kind of where my focus is anyway.
And I understand the court's question, and I guess what I'm trying to impart to the court is, while some adjustment might be warranted,
well, like
the adjustment in this case is totally unwarranted and an abuse of discretion.
She's getting some military pension, which she wasn't getting before, even if it was anticipated. It's more income.
Of course, Your Honor, that's apples and pineapples because that was equitable distribution. And it was well known at the time. Also remember that if Dr. Dunn passes, there are no survivor benefits and there was no COLA. So you have both ends of the equation. You have not just the need issue. If we put that to this side, we have what is the income issue. And that's part of the real problem that I would respectfully submit exists here. In the original judgment, the court anticipated a 6% return, which was never realized, and therefore the so-called phenomenal growth that was identified by the court in its oral ruling and then ultimately the judgment that counsel prepared simply is not a basis for saying that that's an unanticipated change in circumstances.
What would the value of the investment account have been if you had a 6% return from the time of the final judgment of dissolution?
Your Honor, I did not do that calculation, and I don't believe it was ever done in the record. But
it's a question of math, though.
No, I understand. Yeah, sure.
It's not necessarily anything that needed to be testified to.
I understand that. But the point of it
Counsel, you're not arguing that the decrease in monthly expenses didn't constitute a substantial change, correct?
As I think I tried to answer to Judge Cohen, perhaps I was unclear. It can create a change. It does not create the change that justifies what the court did in this case, and that's the point I'm trying to impart to the court here. In other words, if the court, and Judge Evander noted, If the court accepts as an element of the substantial competent evidence standard that the court was entitled to consider the report of the analyst, stale as it might be and as incomplete as it might justify some reduction, but not this reduction, if that answers Your Honor's question.
Well, doesn't it also appear that the trial court, largely, I guess, discounted or did not find your client or your client's side credible and found far more credibility on the appellee's side, which could be a further justification for the reduction, correct?
The only testimony that would have been considered as far as considering the appellee's side would have been the testimony of the analyst, McGill. And Your Honor is correct, there were findings in the judgment as to credibility, but there was nothing that rebutted the wife's testimony about the expenses she incurred for insurance, the fact that her health condition itself was deteriorating, the fact that she had to have 3 surgeries since the judgment and another 3 disc surgeries soon to come. So yes, Your Honor identifies a part in the judgment where the court says, I'm not sure I believe all of this. But there was nothing that the husband ever presented that said she hadn't had damage to her home, that she hadn't had increased insurance costs. And more importantly, there's nothing that says that the court has to accept at face value the, I would say, I won't say arbitrary reductions, but the reductions that the analyst made to various household expenses. I'm going to be getting into my rebuttal time for a minute. If I just for about 20 seconds could address the retroactivity for a moment. I understand the law that in many instances the general rule is that modifications should be retroactively applied. Here it ought not to be. The case lingered from October of 2014 until 2017. Most of those times had nothing to do with the wife. She was not delaying the case. The husband took 13 months to even move to initially set the case for trial. Ironically, the very income that she's supposed to be able to be generating now from this phenomenal growth in her account will be reduced by several hundreds of thousands of dollars if this retroactivity occurs. And moreover, even though the court announced when the rulings were being handed down that she should get some credit for the tax implications, since he's paid all those payments over the years and deducted them, and she's paid the tax on those as ordinary income, the court ignored that in the judgment and did not address it on rehearing. I'll reserve the balance of my time for rebuttal. Thank you, Your Honor.
Thank you.
May it please the court, John Bogdanoff for appellee William Dunn. The trial court found, and there's substantial competent evidence to support both a substantial decrease in the former wife's needs and a substantial increase in her ability to meet those needs.
Well, let's talk about the reduction as far as the decrease in needs. Now, if she had gone out and continued to spend $17,000 a month, and let's say it was undisputed that she continued to spend $17,000 a month for, where she traveled a lot and bought expensive clothes, ate at nice restaurants, etc., and, consistent with the marital standard of living in 2000. In fact, one could argue that $17,000 now gets you less than $17,000 back in 2000. But ignoring that, would that hurt your argument if she decided to spend more money consistent with what she was spending back in 2000?
If the court had found that her expenses approached $17,000, then yes, that would hurt our argument.
All right, then from a policy consideration, does that make sense?
No, for 2 reasons. Number one, to just go back to the first question, not only did the trial court find her expenses in this case—
No is a sufficient answer. If it doesn't make sense, it doesn't make sense.
Well, if I could just explain on 2 fronts, because several things were stated in the initial argument. One is, not only did the court find $8,488 in monthly expenses in this case, but the former wife confirmed during her testimony that the forensic accountant was correct.
You're missing the point, it seems to me, that you punish her for being frugal, for not spending the $17,000 that she had spent during the course of the marriage so that her assets can last her longer. But you've artificially set a new standard of living because it's got nothing to do with the standard of living that these folks enjoyed during the course of the marriage. In fact, the trial judge seemed to be critical of the very same things that they did during the course of the marriage. You know, that they owned 2 airplanes. They would fly all over the place. They owned homes everywhere. You know, these folks lived a very, very comfortable, and that's comfortable is an understatement. They lived a fairly extravagant standard of living. And why isn't she entitled to maintain that standard of living post-judgment?
Because alimony is designed to meet the needs of the spouse. That's what this court has
Does
said.
standard of living have nothing to do with it?
It does, and the trial court in this case found that the former wife's ability to pay her expenses
But
to maintain...
that sets a standard of living based upon her current circumstances and not going to allow her to do the things that she did during the course of the marriage, correct?
No, because the expert testified that these expenses were the reasonable expenses to maintain her standard of living.
Current standard of living.
And she confirmed that in her testimony. She said, he is correct. He used the data, the financial data that was available, and it said he came up with $84.88 a month, and she confirmed that. Now, she, at the time...
I understand, though, the policy...
I understand, but there again, the Mallard case, the Supreme Court said, alimony is not designed to have a savings component. It is designed to meet the needs of the spouse, of a needy spouse.
What needs? Is it the needs to maintain the marital standard of living? Because obviously, there's a whole lot of people in the country that can get by on less than $17,000 a month. You'd agree with that?
Yes.
So needs has to be defined. Needs isn't the real needs to, put food, have sufficient food and maybe a roof over your head. I mean, needs means something beyond that. And certainly in setting alimony initially, assuming the ability to pay is there, the needs is defined as the marital standard of living. Would you agree with that?
Yes.
Okay. So why in a modification action would you then go to needs being defined as what the person's spending then as opposed to the marital standard of living?
Well, because I don't know that there's any right to maintain the total amount of alimony forever. I mean, the cases that were cited at the outset of the argument, Antopenko, Reagan, and Wolf, all say that where there's a substantial change in, or decrease in expenses, that will support a reduction in alimony. Now, in this case, that was the evidence, and that's what the court found, that there a substantial change in expenses consistent with the standard of living that the former wife enjoyed. That was the evidence. That's what the former wife confirmed in her testimony.
Did your expert give any number as to how much money she'd need to spend to maintain the marital standard of living, or did he just give a number necessary to maintain her current standard of living?
I believe what he said was her standard of living. And the trial court found that this was consistent with the standard of living that she enjoyed over time.
Let me ask you about the retroactive application. Was the alimony amount set on the assumption that she'd be getting income from that $400,000 that she'll now have to pay?
That would be included in the sum that, or in the money that she has in her investment account or in her other assets. She has $2.2 million in assets the trial court found.
So the judge set, determined what income $2.2 million would produce.
Actually, it was what income the Merrill Lynch account, which was about 1.7, almost $1.75 million.
Okay, so the judge determined her income based on that amount of money.
Right.
But the judge then ordered her to pay $400,000 of that, but did not change or did not recalculate the amount of money that would be earned on $1.375 million rather than $1.775 million.
But the judge was also...
is that a fair statement?
Yes, but the judge was also cognizant of the evidence that the former wife was going to be receiving a disbursement from her late father's estate of several $100,000.
No, it's not several hundred thousand. That's not
No,
an...
several hundred, I'm sorry.
That's wrong.
No,
It's $400,000 was the testimony, and there are 4 people. That's $100,000 each.
I believe the testimony was 800,000, and there were 5 people. There were her and her 4 brothers. So that would be about 160,000 plus the 60,000 she had already received, which she testified she was intending to use for her 32-year-old son's benefit. But the fact of the matter is, there was evidence of somewhere between $160,000 to $220,000 that she either had received or would be receiving from her father.
Still
her
less
late
than
father's
400,000.
estate. Less than 400, but a substantial amount nevertheless.
Now, as far as the tax consequences, let's assume a 25% tax bracket. He would have in reality only paid $300,000 because he would have gotten a $100,000 deduction, and she would have in reality only gotten $300,000 because she would have paid taxes on it, but she's going to have to pay back $400,000. Is that error?
Well, not in this case, because there was no testimony presented on that. If you read the motion for rehearing that the former wife filed, she simply asked for the opportunity to reopen her case and present evidence of the tax effects. No evidence was presented during the trial. So she knew that the
But
former...
didn't the judge give a verbal order that the parties were to calculate take the tax consequences into account in preparing the final judgment? That wasn't done, and then she filed her motion?
And then the court denied her motion.
And we also, there is evidence as to what his tax bracket was.
Well, but the fact is there was no testimony presented that on the issue by either side, and it was her burden to show.
Know his tax bracket, we know the amount that was received. That's a mathematical computation. Why do you need to have someone tell us the obvious?
Well, I don't think that issue was fully formulated and presented at trial.
Well,
And
that
so-
issue was fully put on your client's plate in preparing the final judgment, correct? To include that calculation or consideration.
The
your client
attorney
failed
for
to
the
do that.
former husband prepared the final judgment. But the former wife acknowledged in her motion for rehearing there was no evidence. She needed to reopen her case to present the evidence. She didn't ask for the court on rehearing to conduct a mathematical calculation.
But the trial judge had already made a decision that tax consequences were to be considered based on what the trial judge heard at trial, and then didn't do it.
And then denied the motion for rehearing after the former wife
Right, after the
raised
final
issue.
judgment did not include the calculations that the trial judge requested.
Well,
Final judgment prepared by your client.
right, and the motion for rehearing, which did not, in the motion for rehearing, there was no allegation that this calculation had not been conducted. The allegation in the motion for rehearing was, we need to reopen our case to present more evidence, Judge, on the issue of the tax effects. And the judge said, that's what you're raising in rehearing?
Did their tax returns come into evidence?
Excuse me?
Did their tax returns come into evidence? And their financial affidavits come into
I
evidence?
do not know. I do not know.
And wouldn't those reflect gross and net?
Well, they might reflect at a certain point what a certain, tax bracket was, but would that be enough? I would say no. I would say if she wants to reopen the case,
Hey, trial judges do it all the time, based on just the tax returns and the
and here there
financial
was no
bracket.
request in the rehearing motion to do it. There was no request, Judge, please mechanically do the computation. There's evidence in the record. You can do this. Please do it. The request
But
was...
assuming the evidence was there, based on the financial affidavits and tax returns, it's not that hard to calculate. I mean, all you need to do is pull out the IRS, chart, and you can do it. I mean, trial judges do it all the time.
If there was sufficient...
And then the trial judge directed that those calculations be made in the final judgment. And then they're not, why should the burden be on them anyway? The trial judge already made her decision.
Because what they asked for was to reopen the case. If there was sufficient evidence, they would have said, Judge, do the calculation. We got the evidence in the record, just do it.
The judge orders
they didn't say
their
that.
tax consequences to be considered, and you all don't do it. And you're here telling us that that's not error.
No, what
I
I'm...
mean, really? Is that fair? Is that equitable? This is they're a court of equity below.
Right,
Was
and
that equitable?
The court heard the motion for...
Was that equitable? In your view, can you say that determination where she has to repay the gross amount without consideration of tax consequences, was that equitable?
Yes, because based on her own...
Then there's really nothing else to talk about.
Well, based on her own testimony, her needs were $8,400 a month, and she was receiving $10,000 a month in alimony.
And your client makes $100,000 a month.
This is based on need. We don't even get to the ability to pay unless we determine...
But we're talking equities, and you're going to throw out these numbers. Well, let's throw out all the numbers then.
Well, look at over the course of 14 years, she received $10,000 a month and was able to save over 14 years approximately on average $50,000 a year.
Well, you're not considering the growth. First of all, there was anticipated growth in that account, and that finding of this tremendous growth, I didn't really understand the trial court's rationale of that. She was awarded an airplane that they own 2 airplanes. That's the standard of living that these folks were, operating on. So she's awarded an airplane that they know it's going to be sold. She's awarded the marital home, which the trial judge suggests to her to sell and get in a less expensive home, which she does. So we know that there's going to be that increase. It's anticipated at the time of the final judgment. We know the military pension was anticipated at the time of the final judgment. And then they anticipated a rate of return that wasn't realized on the account. If you compute the expected rate of return along with those assets, where is there tremendous growth in this account that wasn't anticipated at the time of the final judgment?
Well, the account went from from 1.1 million to over 1.7 million, and that was after she used that interest income to meet part of her needs.
And
so
was the sale of the airplane part of that increase?
that was put into what she did is she sold the plane.
Was the sale of the
and
marital
put it-
home part of that?
The marital home was sold right after the 2000
Did it go into the
final
account?
judgment. What's that?
It went into the account.
And all of that, right, went up, made the account
That's
up
all
to
anticipated.
1.7.
That was all anticipated at the time of the final judgment.
That's not what the trial court found, and that's not what the evidence.
That's right. That isn't what the trial court found tremendous growth, and I'm suggesting to you that I don't see it. And it's not really. This is just basic math. If you looked at the expected rate of return, you look at the increase from the sale of the airplane and the additional monies from the sale of the home, all of which were anticipated, known quantities at the time of the final judgment, there is no substantial growth to that account that was unanticipated.
Well, I think what the court found was, and maybe it shouldn't have used the term phenomenal, but substantial certainly, from 1.1 million to 1.7, and that accounts for the airplane being sold and those proceeds being put into the account. And it accounts for the fact that she used some of that money, the interest on that money, to meet her needs over the 14 years.
What was the sale of the airplane? How much money did they get?
I believe it was around $400,000, and that was put into the Merrill Lynch account.
Right, so that takes it from 1.1 to 1.
That brought it to 1.1 million. The 1.1 is after she sold the airplane, and I believe the Merrill Lynch account was around 600,000, somewhere around that.
Right, and the sale of the house?
Well, the sale of the house, I don't believe there was any evidence in the record as to what the proceeds from the sale of the house. That happened after the amended final judgment had been entered.
But those proceeds went into the account, correct?
How much? I don't know that there's evidence in the record. I don't recall seeing anything in the record that showed how much the proceeds from the house.
But if you're going to make a finding that there's been tremendous growth, don't you think you ought to consider those factors?
Well, I think the court did say it was 1.1 million, and then it went up to 1.7 million, and that was after she used a
But
portion.
if the house had sold for $600,000 more than the house she bought, that would mean there was no growth, right?
Well,
I mean,
I
we don't
don't
know.
believe
It could
the
be
evidence-
anywhere
yeah.
from 1.1 to 1 point, but that's just an example of how her finding could be way off if she doesn't consider that factor.
I don't believe there's evidence that, I believe what the trial court found, and the evidence, there is substantial, competent evidence to support, was it was 1.1 million, the Merrill Lynch, and it went to over 1.7 million.
But there's evidence that the house sold. And there's
Well-
evidence that the house she got wasn't as expensive.
Right, and yet, at
So the
trial-
difference between the two would be some number added to the 1.1 million.
But I don't believe there's evidence to substantiate what that number is.
Okay.
The other thing
Let's
is,
say you took 1.1 million and had a 6% return on it for the period of time. What does that bring the account to?
over 14 years, I'd need a calculator to do that. And to be honest with you, I don't believe there was any evidence in the record to establish that number.
Well, but the point, though, is that was the anticipated rate of return that was used initially to determine the appropriate amount of alimony. That's the figure that they used. And that rate of return was not realized. It was a lesser rate of return. But if you're going to find a substantial change in circumstances based upon tremendous growth of the account, I don't see how you don't contemplate that figure as part of the equation.
Well, I think even with the 4% rate of return, which is what she received, even with that, she averaged $50,000 a year in monies above and beyond her need, because the account went from 1.1 to 1.7. So even after using part of that money to pay her need, she still ended up with almost $700,000 after 14 years, above and beyond what she needed to use for her need in conjunction with the alimony. There's no doubt that this was not, the alimony award was not simply meeting her needs. The alimony award was, in essence, a savings account, which the Mallard Court says that's not what it's for.
Would you agree that needs has to be defined in some way?
That it needs to be defined? I think yes, and I think the
And is the
testimony-
definition her current standard of living, or is it the marital standard of living in a modification action?
Well, I believe it would be, in this case, the court found that it was the standard of living she enjoyed throughout the
Post
17 years.
the
Right.
post
Well, and I
divorce.
think said it in the
And so
marital
I'm asking
standard.
you, is that correct? I mean, is that the standard that the law does require or should require? The current standard of living versus the marital standard of
I
living?
think the court found it was the standard of living enjoyed during the marriage, and I think that was correct.
Where did the court make that finding?
Well-
And if that's so, that's preposterous, because these folks owned homes, all across the country, flew to go to these homes and took vacations and owned, had new cars on a regular basis. I mean, that was not the standard of living during the course of the marriage. Her current standard of living and her current testimony as to the travel and vacations, that was not what was done during the course of the marriage.
I don't think there's any doubt the award of $10,000 in the year 2000 was generous. And the trial court in this case, on page 2, says the former wife's standard of living has not been involuntarily diminished. And I think that certainly suggests that the court's talking about the standard of living that she has enjoyed throughout the marriage and post-marriage. I believe that the question, is there competent substantial evidence to support that? I think the court points to that. And that's, at that point, I think that's our answer.
Does it make sense that $10,000 a month now would support the same standard of living that $17,000 a month did in 2000?
No, I think in this case, there's the evidence was that, and she confirmed that her needs are $8,488. I don't know what 10,000.
Or 8480, let's use that figure. Are you suggesting that 8480 a month would give you, in 2019 or 2018, whenever the final judgment was, would give you the same standard of living that 17,000 a month did in 2000?
Well, I think that's what the former wife said when she confirmed the accuracy of the testimony.
And she confirmed that it met her current standard of living. She didn't confirm that it met her marital standard of living.
But she didn't say that her current standard of living had been reduced. In fact, she claimed at trial her monthly needs were $17,000, almost $18,000. It was $17,900, which was it was within about $20 of what her needs had been adjudicated in the 2000 judgment. And the trial court in this case, as well as the trial court in the 2000 case, said, you're inflating your expenses. You know, Judge Kennedy said in the 2000 order, final judgment, he said, you inflate your expenses. I just, you know, that's a problem. And in this order, a different trial judge said, you're inflating your expenses. And you know, that's not correct.
Yeah.
And
But what I'm trying to figure out, is there any basis to determine that $84.80 a month now gets you the same standard of living as $17,000 did in 2000, other than the fact that she's spending less money? That, on a voluntary decision on her part. Is there some external factor that caused that reduction?
I don't know the answer to that question. All I can tell you is she said she confirmed she's spending $84.88 current as between 2013 and 2015, and that was what she was spending to maintain her standard of living. And there was no evidence that she had reduced her standard of living. She testified she traveled. She testified, you know, except for the sale of the marital house, which had happened in 2000, 17 years before the trial.
Okay.
So
What is your response to their complaint about the staleness of the information used by the expert?
two responses. One is there was no objection, and I think it was an issue for the trial court to give appropriate weight to. And the second is she claimed $17,000. In other words, after confirming that that number of 8488 was accurate, she then said, well, 18 months later, it had more than doubled to 17,000 and change. The trial court said that's not worthy of belief. The trial court also noted there were several items that the wife had put in, or this 17,000, that were one-time amounts that would not be recurring, and basically said, I don't believe you. I don't believe, the testimony that you're offering. And I think that's why the trial court had the ability to then say, this evidence, even though it was between 2013 and 15, I believe it's accurate to date.
All right, Mr. Bogdanoff, because of our questions you went over, thank you.
Okay, thank you so much.
All right, you got about 6 minutes left.
Thank you, Your Honor. Let me try to address, Judge Evander, one of your last questions, which was what was in the record that would establish or point to whether 8488 is equivalent to the needs that were established during the judgment. The only testimony that was actually elicited was the testimony of Diego, presented by the wife, who testified that there had been a 47% increase in the CPI. So you can look to that to see that buying power of a $2,000 had been affected substantially by that. The court also asked a question about tax returns. I would just point to record 3765 and 3791, where the 2016 and 2015 tax returns were admitted into evidence. And to the point that
Both of them or just her?
I believe they were just hers, Your Honor. I will confirm that. I couldn't call up the record while I was sitting there. There were two tax returns, again, the 2015 and the 2016, that were introduced into evidence. And they were introduced on the wife's case, so I'm assuming that they were hers. To the point that counsel raises about that somehow it was incumbent upon the motion for rehearing to either do a calculation as to the taxes, that's simply, we would respectfully submit, not correct. And whether the motion asked for a reopening is a red herring because, as Judge Cohen mentioned before, it is math. Even when the court was announcing the ruling, specifically said, well, the husband's tax rate is 39%. That was basically undisputed. And there was record testimony here that the wife's tax rate was 23.5%. That was established by a couple of witnesses. So that is not a hard thing to calculate, certainly on remand. I want to address one thing that counsel said a few...
I'm trying to, how is it that you want this opinion?
Yes, sir.
What do you think this opinion should read?
Respectfully, what I would submit is the court should find that while a reduced amount of need may be applicable here, and again, the court's already aware through our briefs and the argument of why I think that 84 number isn't the right number. But if there's some adjustment, the court needs to reconsider what amount of reduction is appropriate when considering the actual income sources available to her. And of course, if the court does that and writes the opinion in that fashion, then the court disposes of the retroactivity and the tax implications of the retroactivity as well. So as I said before.
Not really. I mean, I don't think it does that, but.
Well, if the court were to say that the amount of the reduction here, 85% from $12,000 to $1,800 a month, is an abuse of discretion, I don't know what this court could do to say, well, it should actually have been reduced to 10 or reduced to 9.75. I don't think that the opinion could write that way.
Yeah, well, it's an interesting perspective, because I think that my perspective is that this is really about standard of living.
It certainly is. And again, it's a conundrum, and I recognize the court's challenge and frankly, challenges of trial courts. But here, respectfully, and I think it was brought out by some of the questions of the panel, what this trial turned into was a de novo redetermination of this lady's entitlement to permanent alimony, period. She was attacked because she took in her dad during his final illness. She was attacked because she was trying to help her adult son get back on his feet. She was attacked because she didn't disclose the VA account that she got that she was using for her son. Now, I recognize...
She was attacked because there were serious issues raised about her credibility, and that's fair game.
I understand it's fair game, but what I'm saying, Your Honor, is I think that it was, to some extent, a red herring, and it was indicative of what this case turned out to be. Not the husband's burden to show a substantial change, but the burden upon the wife to justify her living, to justify why she was entitled to the money that she was receiving.
And if there should have been a reduction, even if the amount of retroactive alimony was incorrectly determined, where would the error be in awarding a retroactive determination?
Because in this case, Your Honor, and the cases, the Bloom case, I think, was most indicative, and we cited it in our brief, that while retroactivity is often the case when there's a relatively short period of time between the filing of the petition and the relief, when you have many years, as here, and delays that occurred because of judges that were disqualified, illnesses of judges, joint motions by the party saying we're not ready to try the case, 13 months before the case was even first noted to be at issue.
What's the best case for your assertion of that rule of law?
Probably Bloom, Your Honor, because as I said, and I think the cases in our brief go into the whole issue. We recognize that there's the general rule, but just like all general rules, they are subject to exceptions.
Yeah, but go ahead.
Did the Bloom case take into account substantial questions regarding credibility?
I don't recall whether that was an issue, Your Honor.
But as a court of equity, if let's say the husband's paying $12,000 a month alimony and it should have been 10 as of 3 years ago, why shouldn't the trial judge correct it?
But again, because in this instance, it is a double punishment to the wife. Not only is she being reduced substantially, but the very premise that the husband comes into court with, saying, look at all this phenomenal growth.
Right. I agree that in calculating her income, you have to back that money out, or else you're double dipping. So I get that, but I'm just talking about the overall policy of going retroactive.
And as I said, I think if you look at cases like Bloom that explain what's the rationale for retroactivity, and I would respectfully submit to the court that in this particular case, retroactivity operates as a punishment to the wife, and it's an uncalled for punishment. And I know my time has expired, and I thank the court for
I thank you both.
Thank you for your questions, Your Honors.